Thanks very much for that introduction, Bill. I'm excited to be here once again. I think this is my 12th annual. So out of 13, I've been to 12. And I don't know how many case law panels I've hosted, but it's always a pleasure to be able to open the conference and kind of set the stage for us with what's been happening in case law. For those of you who aren't as familiar with everyday happenings in discovery and electronic discovery, the pace at which case law changes in the United States courts on these issues is incredible. For the last 5 years, we've seen more than 5,000 decisions on the discovery context, and it is a challenge for us each year to choose just a couple of topics.
Excuse me in here, please. We need to keep the volume down. It's going out into the conference room, so please keep the volume. If you need to chat, please go out into the courtyard.
I think, Bill, your microphone's live. Okay, so with that in mind, we've created a few topics for you today, but first I want to take just a minute to introduce our panelists, of which, unfortunately, as a result of the snowstorm on the East Coast, we are down one. But to my immediate left, please welcome the Honorable Xavier Rodriguez, who is a United States District Judge for the Western District of Texas. He's been on the bench since 2003 and has generously gifted his time so much over the years to speaking and writing authoritatively on discovery issues. And I feel like I'm screaming into my microphone. Sorry. So I'm going to turn just a little bit so it doesn't seem so much like that. So welcome, Judge Rodriguez. Thank you for being here. To Judge Rodriguez's left is Maria Salacuse. Maria has been with the EEOC as Assistant General Counsel for Technology for more than 20 years. We'll just go with that. And
with the EEOC for more than 20 years is a lot more than 20 years. But in this position for more than 5 years.
Okay, and really responsible for advising on electronic discovery issues for more than 300 attorneys, paralegals, the entirety of the EEOC.
Correct.
So we're ecstatic to have you both here. Sandra Metallo-Berrigan was also supposed to join us today. We miss you very much, Sandra. So hello to everyone from the panel, and we'll have you back next year. Diving in, I think, to our topics, and of course, we always have our standard disclaimer that the opinions that you're going to hear today do not reflect those of our employers. Couple of themes as we get underway. We have, for the last really 20 years since we've been talking about dealing with ESI as evidence, have talked on a custodian basis. And as we shifted to cloud-based platforms, and even more so as we move into the issues we're going to discuss today, we're talking about discovery more as a system-based issue rather than a custodian-based issue, because where custodians used to store their data locally, now all of that data is stored in the cloud, and we need to be talking to the individual systems and thinking about those systems as a whole. If you just listened to Dawson Horn's keynote address, which was incredible, and if you didn't, I recommend that you go back and do so. He laid out for you how generative AI works, how the LLMs perform what they're performing and what those issues are, and we are now seeing those issues bubble up into the case law, and we're going to talk about some of those today. AI is one of those systems that you have to be thinking about when it comes to your obligations to preserve, collect, and produce information. As we mentioned, case law is really what provides us our strategic edge in discovery, because we have to know what the courts are telling us about what our obligations are with respect to these individual systems, and we're going to dive into some of that today. Our very ambitious agenda, as I look at the clock, which is already down 3.5 minutes, is to talk about mobile device discovery, specifically possession, custody, or control, and that requirement under Rule 34. We're going to dig into 2 issues on AI. One is prompts and preservation in the open AI matters, but also a second issue that's come up in the last 2 weeks. You heard Dawson mention Judge Rakoff's decision in the Hepner case and the issue of privilege that has arisen. We're going to also address that. We'll work hard to get to hyperlinked files and potentially Rule 707 as well. Let's dive into the first topic, Judge, and I'm gonna set this one up for you. You and I had a conversation on my podcast, the Meet and Confer podcast, this past summer, where we talked about the need for the case law to evolve in determining possession, custody, or control as it pertains to an employee's personal device and whether or not the employer has control over the information on that device to provide it in discovery. Can you do as you did lovingly on our podcast and set that up for us in a way and talk through the tests that the court currently applies and where you think we need to go here?
So, thank you for the invitation to be here, and thank you for the invitation to be on your show. We started talking about some recent cases discussing possession, custody, or control regarding mobile devices, and cases are all over the board. You all know this. So there's two primary tests in the United States. There is the legal right test, and then there's the practical ability test. The practical ability test says, well, if you're the general counsel and you have the ability to go down the hall and say to the president, hey, we've been sued, hand over your phone because there's stuff on there we need to retrieve, you have the practical ability. The legal right test supposedly holds for the proposition that there's got to be some kind of contractual legal agreement that allows someone to get to a phone. So in the vendor context, that's a little easier, right? You know, the vendor context, normally you have an agreement with your outside vendor and you throw in some clause saying if we ever get sued, you have to cooperate with us. That'll fit. And then there's a whole bunch of hybrid tests that everybody has created around the country that add confusion to all this. There's some courts in the country who have literally hybrided both tests and have language of possession, of legal right and practical ability in there. And it's like, well, what the heck's that? And so the case law is very garbled out there. And so then Bill was kind enough to send out a request for folks to write about these things. And so I figured, well, that was an interesting conversation I had with Kelly. Let me pursue this. Possession, custody, or control. Possession's real easy, right? You actually have something in your hand. Custody, that sort of makes sense too. You have some kind of custodial obligation to keep something. Control, that's where I started going off on, well, what does control mean? If it's not already covered by possession and it's not already covered by custody, what did they mean by throwing this word in here? And good Lord, I went off on a goose chase. So I went all the way back to the rules creation in 1934 going, what did they intend for the word control to mean there? And it's never defined. And it's like, okay, so the morass was created way back in 1934, and we've carried it forward today, and have come up with these two tests that we've just sort of created out of thin air. And this is the world you all have to enter into. And so going to cases, there's a case called Allergen versus Rivens.
Can I interrupt you for just a minute first? So if you were part of the conference last year, we talked about this topic as well last year. And we talked about how the courts in 2024 and some in 2025 are all over the map, right? Some of them don't even mention the legal right or practical test, and there isn't even hybrid language. They just gloss right over it, and they just assume that the employer has control over it. Now, whether that's because the parties don't raise it or whether the court doesn't want to entertain it, we've seen courts that have explicitly
I think some courts are just like
rejected it.
Well, yeah, I think some courts are just offended under the facts of whatever case. The fact that you're not producing this mobile device just sort of offends the court. And so they don't even talk about tests. It doesn't pass the smell test.
Right, which is
it's a new test, a smell test.
Is hard to know how to argue, Judge. It's hard. Yeah. So I think that's where we find ourselves. So with that, I'll let you kick into the allergen test and also the sports rehab.
Yeah. So allergen's kind of interesting. This is a theft of trade secrets case, and so talk about the smell test. Right off the bat, the smell factor has already permeated the room, right? Because everybody is like, stuff used to belong here, and now it's over there, and how did it get there? And so the defendant here is requesting text messages from a person named Dr. Kenneth Clark, and it's a company-issued cell phone. So that they're, well, it looks like they're in possession of that phone. It's their phone. Or is it actual physical possession? I mean, to me, the fact that it was a company issue phone is enough, but this is where all these distinctions start coming into play and courts start getting all confused. I mean, I hardly, in my personal opinion, my colleagues can, of course, disagree with me, but the fact that, it's a company phone, which they can request at any time when that person leaves to return, should have been enough. And the court somehow starts going off on, well, I'm confused. Who had possession of the phone, physical possession? That's an interesting take on that. The other interesting take on this case is a special master was appointed. That always, no offense to all my special master friends out there, do we have to hire a special master for every case now? I'm not sure that this case really necessitated a special master for this issue, but I'm always worried about cost. And so the bigger factor on this case is preparation. So apparently no one could answer questions about what happened to the phone. And so the special master, this is the ruling, that they must provide a declaration about the phone's disposal and produce relevant retention policies. Oh, what a kick the can down the road ruling, which somebody paid a special master a hell of a lot of money for.
Yeah, I think, and what's interesting to me about Allergan too is there's no set, here are the 4 things that need to be considered, right? And if the phone is company issued, then people will argue, well, what are the policies associated with information on the phone? And does IT only manage certain aspects of the phone? There's no consistency across these rulings. So it really is a situation, and as we look at, and then there are completely divergent rulings, right, in terms of consideration. But then when you move to something like the sports rehab case, in that situation, we get to a concept that the courts have been fairly consistent on now, which is when a company does not have control of a phone, the party who wants access to the phone needs to submit a third-party subpoena to the individual's phone who it is. And in the sports rehab case, the situation was essentially that the plaintiffs didn't submit that subpoena for better than 3 years. And by the time they did, discovery had closed. And the court said, discovery's closed, you're too late. I don't know why you didn't do this 3 years ago. The other side told you they don't represent these individuals. They've told you these are not company issued phones. You should have submitted these subpoenas. So the takeaway, the few takeaways here are, you've got to know to be able to make this argument early, and you've got to be able to act early. And when you're going to need to issue a third-party subpoena, you need to do that quickly, because if you've been in the third-party subpoena arena, it is very difficult, and people do not want to respond, and they do not want to give you what you're asking for, and they do not want to give it to you in a form that is going to be usable for you. So it's really important that you get out ahead of this issue very early, and you're understanding what's happening with it.
I would have a meet and confer really early on too with the other side to figure out what's going to be their position on PCC. Are they going to go ahead and agree to look at this stuff? Because the other side may actually want that phone too. Yeah, I think, I would not be waiting for a formal answer. I'd be having those kind of conversations real quick.
Yeah. Maria, what's your take from the plaintiff's side?
No, I agree completely with the judge that, in general, the practice should be that in your Rule 26F conference, you should be addressing that issue. The mobile devices, what's your position with respect to possession, custody, and control? In fact, in some of the letters before the Rule 26F conference, it might be a good idea to highlight that issue so that when they come to the 26F conference, they specifically address it. And I've also seen it in ESI protocols where that is specifically addressed, making the other party take a position. And why you do that is because if you don't do that, you have the potential that the device may be destroyed, lost, whatever. So we want to get our hands on this as early as possible so we don't have spoliation.
Which means that you need to be having conversations with your client as early as possible so you know who those people are that potentially have the mobile devices. Everything has to be done earlier and faster with ESI. And Judge, in your article, and I just want to spend a minute on this because I definitely want to turn to the AI, issues. You proposed a new agency theory to replace the legal right and practical ability standards. Can you tell us a little bit about that?
Yeah, so I'm generally considered a moderate, so my goal is to get everybody mad at me. And so I'm saying let's get rid of these two tests. The practical ability test, the idea that you can just go to somebody's phone, gather it, make them give up the, the whole thing, this just strikes me as there's going to be some privacy implications here that are going to be at play. And if you have GDPR concerns, we're going to have all those kind of issues. So I'm worried about that issue. On the legal right test, I'm worried about, depending on how someone wants to structure their agreements, and we've already seen it in BYOD policies. Okay, yeah, you have to turn over your phone data for this, but not the text messages. Well, then everybody goes to the text messages to cover what's relevant in the case. So I find fault with both of the existing theories. I'm proposing an agency theory. It would be a bright line test. If it's an officer, director, supervisor, manager, then they have you have an obligation to produce any kind of relevant data from that phone. If it's a regular employee or anyone else, then you have to issue subpoenas. And so everybody knows how the game is played right from the beginning. We don't have these fights over this is going to be legal right or it's going to be practical ability. And everybody knows to immediately issue third-party subpoenas, and I'm sure it's ripe for criticism because I'm sure there's some flaw in here I haven't thought of.
And what I'm interested to know is, and this is probably for cocktails later, is how do you get this new rule out there? So do you just rule on a case and drop this agency theory in? Since legal right and practical ability, they aren't codified law anywhere, you could just come up with a new theory and start spinning it?
That's sort of what judges are doing now, right?
That's true. That's true. That's true. That's true. All right. Anything else on that topic, Maria? Before we move to the AI. Okay. So from phones moving over to AI, from where is it to what are we talking about when it comes to generative AI? And we're going to start here with talking about AI prompts and preservation, and really moving into the OpenAI cases. For those of you who are not familiar with them, you'll see them on the next slide. The OpenAI decisions was a series of cases, predominantly in the Southern District of New York, in which the New York Times and a number of authors sued OpenAI for using their copyrighted content in training their models and allowing users to receive responses when prompted to get to that content. And it has created what were essentially the first rulings on generative AI prompts and your obligations to preserve. And I'm going to turn it over to Maria to really talk us through several of the rulings in the OpenAI case.
Yeah, I've been tracking this case because I think it is just fascinating. I've looked at the underlying pleadings. A lot of them are heavily redacted, but you can still get a lot of content out of it. So, I encourage you to look at the underlying pleadings. But as Kelly said, this is a copyright infringement case and against OpenAI by New York Times. And OpenAI's defense is fair use. And so that comes to play, and I'll explain why I'm highlighting that. So what happened was they were sued in December of 2023, and then about a year later, there's some discussion that OpenAI may be deleting some of the output logs. The term output log, by the way, to me it sounds like, it's only the output. It actually, from what I understand, is input and the output. Yeah. So your prompts and your
prompts
output.
And answers. Yeah.
So the term output log kind of confused me, but just know that it's both. So there was some indication that there might be some deletion. So the issue was raised to the magistrate judge, Judge Wang, who initially, the plaintiffs were seeking a very broad preservation order, like a really, really broad preservation order. And Judge Wang was reluctant to do that kind of wholesale preservation order, and instead she kind of posed some questions to OpenAI about, is it possible to segregate and to anonymize these output logs? And you can sense some frustration with the defense counsel because defense counsel wasn't quite answering the questions. So during a couple of months, there's kind of back and forth, and soon New York Times finds out that there is some ongoing deletion happening. So they return to Judge Wang and say, hey, we just found out there's a lot of deletion going on here. Not only did they return, they brought with them an expert with a declaration who substantiated that there was some deletion. And in particular, the spikes of deletion were happening right after the complaint. And so the judge at that point, which was May of 2025, was concerned and said, well, wait a minute. And that's why you see this, preservation. This is what got all the news, this preservation order, which basically said, okay, I want you to segregate and preserve the prompts which would otherwise be deleted. Now, OpenAI was not happy about this.
And that's everything. So if you deleted a prompt, at that point, OpenAI was keeping it.
Yes. So they weren't happy about it because, all their users are like, well, wait a minute, I have the ability to delete my stuff. And the judge made very clear that even though the users have the ability to say, delete the stuff, they still had to preserve it. So it was kind of a nightmare. So OpenAI continued to just object, but the preservation order stood. And then what happened was similar, and I don't know if you followed the Anthropic case, similar to what was done in Anthropic, the parties negotiated a sampling process because at issue are tens of billions of outload logs, tens of billions, if you can imagine that. And they negotiated a sample of, which would be about, I think it's 0.2%, for 20 million prompts. That's what they negotiated. So the judge thought there was a deal there, thought everything was moving forward. Well, OpenAI decides, you know what? Yeah, we're going to do the sampling, but we're going to apply search terms to it. And so, of course, New York Times has to go back to the judge and say, wait a minute, this is not what was supposed to happen. The judge was annoyed, from what I can tell, and basically said, no, that's not the intent. And by the way, you put at issue all of these output logs by pleading the fair use defense.
That's right.
Which
is totally as a side note. How do you come up with search terms?
Yeah, I know.
Anyone in this room, because the best and the brightest are in this room or they're online. Anyone have any idea how you'd come up with search terms there?
In this copyright case.
Yeah.
So after that, if that happens, they continue to object, and that seems to be the thing that's going on with OpenAI. And eventually it gets before the judge. They try for a stay and it doesn't happen. Eventually it gets before Judge Stein, who affirms all of the rulings of the judge. So the case is continuing to move forward, and I think it's a really interesting case, and you should keep an eye on it because there are going to be a lot of nuggets that you can get out of it.
And really, your takeaway is that prompts are ESI, right? Your prompts, the output log, the prompt, and the corresponding information that's produced as a result of the prompt is part of what's included in that output log. Those are ESI. They are discoverable. This is a civil case, but it was against OpenAI. So the question becomes, will OpenAI or other AI companies use the Stored Communications Act to preclude providing information in civil discovery where other parties may request it, right? So not where the AI party is or the AI company is a party, but where they might be a third party looking for information. Judge, what are your thoughts here?
So another issue that comes in is whether, at some point they raise privacy as an issue here in the requirement to produce, and whether they did it. I didn't have a chance to do the deep dive that Maria did. Whether they did it as a separate 26C objection, or whether they tried to do it within the usual 26A1. Standards for proportionality, that was unclear to me.
I thought it happened in both, but it definitely appeared. I would say both. But
So we all had our stuff in there. Everybody in this room and online, right? And so who's going to raise our concerns that our stuff has been required to be produced? And so, this is a highly complicated case. So I don't know it well enough. So I'm not. Necessarily taking a position on any of this stuff. But, here's the issues I raise. There is a lot of impact on a lot of people here in this case. And I perhaps would have given that a lot more consideration. The second fact is, this is a copyright violation case. And so the plaintiffs got to prove that their material had been copyrighted by the New York, by OpenAI in some form or fashion. And so, I mean, why aren't we dealing with the analysis of how do you believe that the stuff was copyrighted instead of going straight to we need to gather gabillions of chat logs? I am
Well, isn't
having
the problem, though, that they were being deleted? That's the problem that came up because OpenAI has retention policies.
So if it was deleted, so what? There's a whole bunch of other material. I mean, if the complaint is that the way OpenAI has developed its seed set is it gathered stuff from all these media corporations and it violated their copyright, that training set is what it is at issue.
But I think the damage becomes these users can prompt that information. So I don't have to read, I'm going to make someone, who's the comedian? Sarah Silverman. I don't have to read Sarah Silverman's book because I can say to OpenAI, give me a summary of what Sarah Silverman says and tell me all the best jokes. Right?
But all I'm suggesting is maybe we figure out whether it was a violation of the Copyright Act in the first instance before we start invading the privacy rights of hundreds of millions of people out there.
Well, all this content is anonymized, right? So they have.
So ultimately,
they have a
that's what
process.
happened. They anonymized.
Yeah,
Right.
I mean,
they have a de-identification process for
and
everything.
so all these folks thought when they hit delete that they got deleted too. I'm not sure that they're all that satisfied that supposedly it's been de-anonymized.
Okay, we have a question, I believe.
Probably just more of a comment. Aaron Amadea, head of applied science at Relativity. Anonymization is just one of those impossible problems. If you have millions of documents and you're trying to prevent any kind of personal information or sensitive information from leaking, it's just, I don't want to say impossible, but it is far beyond the capabilities of current systems today. You can do a decent job of removing PI and trying to anonymize, but you cannot completely.
From within the content, I totally agree with you, Aaron.
Yeah.
But in terms of being able to remove what the usernames are and the identities responsible for creating the output, that's easier to do.
Yeah, we've just seen this time and again. There was a famous case with Microsoft where they released a bunch of search queries. There was a Netflix data dump and a data challenge. There have been other medical records and other sort of every single time we've tried to release large amounts of data to anybody. We've done some amount of de-anonymization. We've done some, but I don't think that you can fully protect somebody's individual
100%.
prompt from all of that stuff.
Now,
but I
in
wanted to come
fairness,
back.
I think what the magistrate judge does, and thank you for Aaron for agreeing with me, but those kind of agreements are always welcome. The other thing that the district judge in sustaining the magistrate judge's work is, anyway, this is all subject to protective order, and so there we are.
And I'll just make one more point because I think you did a really, really good job of saying this. Like, if they did in some way copy or illegally take advantage of this material that was available outside, then that information is in the seed set. That information is in the large language model that was being used. It's in the system and the safeguards that were around it. I don't understand why they were looking at all of these logs, because there's all of these other ways that you could test or probe or show that the copyrighted material had been improperly used.
Can I address that?
Yeah.
Well, first of all, in the complaint, if you look at the complaint, I recall there was a long attachment which showed like verbatim, how things had been copied. But I think it really goes down to the defense issue, the defense that was pled.
Yeah.
And so all of that is at issue. I mean, it's not just for the defendant, it's also for the plaintiff.
But isn't fair use just sort of a legal doctrine? I mean, why do you need that underlying chats from all these individuals to establish fair use? It's not that I, as a user, am engaging in fair use. We're talking about whether what OpenAI was doing is fair use.
Well, I am definitely not the expert in copyright, but just from a
it's a complicated case.
Yeah,
so
it is.
I don't want to make it seem like I'm being definitive here. It is a complicated case.
Yeah. I think really the takeaways are, thanks, Aaron. That's huge. I really, really appreciate the input. It's a really, your prompts are going to be discoverable. They're going to be evidence. It's an ongoing area of the law. But in this case too, prompts as evidence of intent is kind of a holy crap. because, we put some examples here of what are some potential prompts here that people could be putting into an AI tool. But, what if your marketing department has a new campaign and they go, tell me if there would be any legal challenges to anything if we used this slogan, right? But they haven't run it past legal. They're doing it without any input of counsel, which we're going to talk about in just a minute. And so is that discoverable? Does it show that the company knew that there were potential legal problems with this before they then put the market out into the internet? Yes.
Okay, we have an online question that sort of brings this case down to the user level and what the implications are for the user. And if AI system evidence is often ephemeral and the output logs that aren't retained, there's raw training data that's not retained, and there's information that may not be retained about the exchange, how does possession, custody, and control requirement for AI compare with traditional discovery in this area?
Do you understand where they're headed?
I think they want to know, how do you apply possession, custody, or control to generative AI information that's held by a third party?
Yeah. So, is this just like, I'm going to try to make an analogy to just old school internet. If I have on my computer my current internet history and all that, I have PCC of that. So likewise, if I'm using AI and it's retaining a chat log history, I do have possession of that, but I think there may be co-possession in this case, that I have it and the AI provider has it. But Dan Regard's going to correct me.
No, I'm going to agree with you.
Yeah.
If you
Always welcome.
Some of these applications.
Microphone. Everyone can always hear Dan.
I was going to say it can vary from application to application, but most of the AI tools we're seeing today are SaaS offerings. So even though they have custom browser interfaces and applications, the majority of the content is stored online in the SaaS environment. So it really is, you have access to it, but it's housed at the destination. You'd have to look at your terms and conditions of your user agreement.
But many of the tools will allow you to export your chats, your logs, essentially. So you need to understand which tool you're using in the same way that you need to for any source of ESI, what your ability is to export that information.
Particularly enterprise systems.
Right. Yeah. Yeah.
Shall we go to something easy like hyperlinks?
Right. Well, we have a
No,
bigger
not yet.
fish to fry, right? So in the last 2 weeks, as you mentioned, Dawson mentioned in his opening keynote, Judge Rakoff's decision. In the last 2 weeks, we have had two decisions. The first, no one really talked about, and the second, everyone talked about. And so let's start really with the first one. Two decisions on privilege issues associated with the use of generative AI tools. Two very different fact patterns. In the first fact pattern in Warner versus Gilbarco, we had a pro se plaintiff who at her deposition was questioned relentlessly, and the defendant sought to have any prompts, essentially output logs of information that she had put into, I think she was using Claude, right? She was using Claude?
No, she was doing ChatGPT.
She was doing
Other one
ChatGPT,
was
and the other
Claude.
one was Claude.
I
So
think she used it in her briefs. Those were pretty good.
they were
Yeah, they
really
were
good.
For a pro
We actually-
se?
Maria
Yeah.
and I said the same thing.
Yeah.
We were like, she used ChatGPT to write
Yeah.
that brief.
Well written.
So anyway, she's a pro se litigant. She's using AI tools, and the defendant sought to have her produce that information, and she objected and said, well, these are all my thoughts and legal impressions. And what was really interesting is the language that is in her brief is verbatim what's in the court's opinion. And it's so good that you really go, that has to be Chat. That's what we said last night. It has to be ChatGPT that wrote that. So essentially, the court said that the plaintiff had waived the work product privilege by putting information into ChatGPT, and the court said, no, these are her thoughts and impressions. This is a fishing expedition. There's no waiver here. But what is perhaps the most important piece here to me is that this court, I believe it was Judge Petty, said that ChatGPT is a tool, not a person. Contrast that to what happened a week later in U.S. versus Hepner, in which Judge Rakoff, and this is the decision that kind of set the world on fire on LinkedIn anyway, talked about, he said in his oral ruling from the bench that AI is a person, and the criminal defendant in that case who communicated with AI and who uploaded information even from his lawyers to AI had no privilege, no attorney work product privilege, and no attorney-client privilege, right? The attorney-client privilege makes sense because he wasn't communicating with an attorney. An AI tool is not an attorney. But what's interesting is that Judge Rakoff held that AI was a person and not a tool, which is a big difference.
Yeah, both these cases, where to begin? So, I think Judge Rakoff has got it right. Under current existing precedent, there was no attorney-client privilege and there was no work product privilege. What I'm wrestling with both these cases is, yes, that's current law. Does that make sense for where we're headed with all this? So, in the Hepner case, we have already, the client has a lawyer, right? And so the lawyer didn't tell him to do any of this, but he gets on a tool and starts running some queries, and it produces 31 different responses, and they hold that none of that's privileged. I mean, is that I don't think that that's going to apply to our world moving forward. I think criminal defendants are all going to, as soon as they get an indictment and they get a lawyer, they're going to want to access these tools, try to engage with them. Maybe that's all a good thing, right? So they can have better discussions with their attorneys. Likewise, in the civil context, I mean, just think of all your managers, supervisors, everybody else that's going to start turning to ChatGPT to have an understanding of stuff. Now, the world going forward, we certainly can't be protecting nefarious activities. Managers can't be going to the employment world. Managers can't be typing about how can I create an artifice to engage in racial discrimination and hide it really well, right? We're not going to protect any of that stuff. But when you have a piece of litigation and you have a lawyer, should we be creating a paradigm where we're going to allow more meaningful responses to your lawyer? I kept on trying to figure out okay, I'm talking to my lawyer, I'm taking down notes. I think that's privileged. I can keep my notes, maybe, depends on what I write on my notes right now, right? And then what if I then take my notes and upload them into an AI tool? I mean, why should that lose its privilege because I've done that? So Judge Rakoff says, oh, well, you sent it up to this tool and there was a waiver because that's not protected anywhere. You've sent it up. And I'm thinking to myself, well, I'm assuming it was a free tool that they were using in this Hepner case. But what if it was a $20 tool or a $200 tool? All of a sudden now we're going to protect that because they paid $20 because the terms of service provide some extra level of confidentiality. And then some people have made this analogy, oh, well, when you start putting it up into an AI tool, that's the same as putting it up on a marquee there in Times Square. It's like, well, no, it's not. They're not completely posting your notes when you
no one else can see it. No one else can see it unless you share it with them.
I'm not sure that analogy works all that well either. But I will say, I think under current law, that's right. Hepner is right under current law. I just question, does this make sense?
I think both of them are right under current law.
I was going to say that Sam Altman.
Make a comment and then we'll get to David's question.
Sam Altman is pushing for an AI privilege. He's been open about that, and there's been some discussion about that, which is interesting.
Good luck with that, Sam.
Right?
David.
Judge Rodriguez, thanks, Kelly. Judge Rodriguez, this is somewhat of a preview of what I hope you'll be discussing this afternoon, but say that instead of Mr. Hepner running this search, it had Mr. Hepner's lawyer running the search. Then is it work product?
Yeah.
And that's exactly what the Gilbarco decision is, right?
Yeah.
They essentially said because she's a pro se litigant. I'm so sorry.
No, go ahead. No.
But
you're doing great. I'll tell you when you're wrong.
Okay, thanks. Because she was a pro se litigant, she was effectively acting as an attorney, and therefore everything that she put in and everything that she got back were her thoughts and impressions. So I think that answers that question to me. pro se or not. She's acting as an attorney. I know. Sorry.
You know,
On the record?
but you know, so again, under the reasoning of Heppner, if a lawyer's using a free version of some AI tool, I think that that reasoning stands for no, there's waiver of any even work product privilege. But if you're using a tool that's got this $2,200 price tag there, I think you're okay. That's just me talking. Yes, sir.
I don't know if he made that distinction.
He
talked
didn't.
about the confidentiality, but he didn't talk about whether it was a free or a paid tool.
He looked at the privacy policy very closely, and from what I understand, the privacy policy, by the way, has changed a little bit. But
Of course
it used to be. It used to be like, we can use your data, we can share it with third parties.
And from that, I'm inferring it must have been a free version, but it's not said in the opinion.
Robert has a question.
More a comment than a question, in the sense that it's one thing whether Gen AI can create privilege. But to say that using Gen AI would waive privilege is a very different thing and a really problematic issue. And for that reason, I think the Warner decision that just says Gen AI is a tool and doesn't waive is clearly the better position. And I think everybody's getting wrapped around the Gen AI implications of Rakoff, but the problem is the language and like looking into terms of service and things like that. It actually implicates lots of other communication tools.
Right. Agreed.
Right? There's
100%.
all kinds of email now is all in the cloud, right? It's in Azure, it's in, all these different and chats, you name it. There's all kinds of different administrators, third parties that have theoretical access to this information. None of them have actual access. Nobody's actually looking at these emails. So it's all theoretical. It's not a disclosure in fact. And so that's what I think the actual analysis.
I think you're absolutely right, Robert, and you rephrased it much better than I did. I mean, I'm real concerned about, the fact that we're using Microsoft Office products, Adobe products, and all that the same, according to these opinions, the same analysis should apply. Yeah.
There's actually some language in the Gilbarco decision where the judge specifically says, if you look at this as a waiver, then you're implicating every tool that every lawyer uses.
Yeah.
So that language there is, I 100% agree, Robert, that the Gilbarco decision is a much better reasoned decision from that perspective. But what's interesting is that we spent an awful lot of time talking about Rakoff's decision and nothing about Judge Petrie's. Ralph you got a question from online?
This is an online that's kind of interesting. Regarding the principles of agency, just like hiring a private investigator to assist your case, they would normally be bound by work product privilege. Is it not the case under generative AI being regarded as an agent and bound by work product privilege?
Well, going back to that New York Times discussion we had, we found out that, a court can order your stuff to be produced. I guess, they could do that with your private investigator too. But
I think the question is, does privilege apply to your private investigator?
Well, yeah, certainly yes.
I think
if it's hired by an attorney, I think that's still.
And I think that's where we're getting into the challenge here, right? Is we're trying to apply current law to these new and evolving situations, and the point that Judge is making and that we're trying to get across is we're going to have to evolve our analysis. Right, in so many ways: possession, custody, or control, analysis of privilege as it pertains to Gen AI, and it's not just Gen AI that's creating these problems. It's right in front of our faces at the moment, but it's not just Gen AI because how many of you are using Copilot? Copilot is generative AI. In case no one's thinking about that, that is generative AI. So every time it fills a sentence for you, you're using generative AI. All right. Any other questions, comments on this one? Otherwise, we'll move on if we have just a few minutes.
I just was going to say one thing that, I think this whole discussion of Gen AI prompts and stuff may be appearing in some of these 26F conferences. Particularly in my cases, I can see that. I mean, you gave the example of, somebody trying to write like a termination letter, make this sound like I'm not retaliating against them. So, you may start seeing that. And I read the deposition in that, in the
Gilbarco.
Yeah. And it was interesting. I mean, they were clearly phishing, though. It was very much phishing. There didn't seem to have like a reason to believe. They just were like wanting to know why she was using this tool and for what purpose and things like that. So I think the judge was
interesting set of facts, though, because Barco, she was the plaintiff and a pro se litigant, right? So she's representing herself, so she has two roles. She's the plaintiff, and she's answering questions as they pertain to the facts of the case, plus she's also the lawyer, and the issue was with regard to her using Gen AI for purposes of getting legal impressions to represent herself. So two totally different things. If she testified she was using it to investigate facts about the case, then that might have been discoverable if she wasn't representing herself. So
no, she just testified it was to draft her complaint and, you know, the pleadings from what I recall.
I mean, we don't have good answers to these questions because every time we're in front of a court, we are limited to the set of the facts that we have in front of the court. And that gives us a very limited decision. And that's why constantly looking at all of this evolving case law is so important. Let's switch to everyone's favorite topic, hyperlinked files. We've covered this one maybe the last 2 years, maybe even more on the case law panel, and it's one I frequently cover on a case of the week. Hyperlinked files are now, they're discoverable, right? So for those of you who might be new to this topic, which I hope is not too many of you, instead of having physical attachments with communications now, whether that's email, text, otherwise, we are now sharing documents via links. And the question is, when you have a link to a document in an email or another type of communication, are you entitled to get the document that lives at that link? And if you are entitled to get the document at that link, how much effort is it going to take to get it from a proportionality perspective, and which version of the document are you going to get? And this really comes down to the limitations of the technology that exists to give you those documents at the hyperlinks. And we've talked over the last few years about the evolution of case law since Judge Parker's decision in Nichols v. Newman in 2021, in which hyperlinked files were not attachments. We have thankfully moved on from that to the point now where judges, not uniformly, but consistently, are saying that hyperlinked files are discoverable when they are relevant and when the technology allows you to get to the information. And so now we look at a couple of cases in the Hubbard versus Crow and Young versus Salesforce. And these cases are interesting from a perspective of where the hyperlinks lived. So in the Hubbard versus Crow case, the party had given
they're doing a podcast.
Yeah,
and so the podcaster sends to the interviewee a link to open up, and they can preview the podcast. And so they open it up. They claim that this is streaming, so they could not save the link. And when they opened it up and saw it, they didn't like about 4 minutes of it and requested it to be edited and cut. And they told them cut. And so the podcaster then cuts. And so the question becomes control, and who has control of this hyperlink. And I thought that was an interesting decision here. They're out to sanction this party because they told them to edit. But if it was just a streaming link, I mean, do you have control?
Yeah, but the edited portion of the podcast was what was relevant for purposes of the case. And the court said, you had the unedited thing and you told him to edit it, so you're responsible for it. I think from a control perspective, it was a terrible decision, but yeah. So we're really reaching into some places here. I'm going to go quickly because we have just a minute left.
Time flew.
Young versus Salesforce basically said that hyperlinks could be discoverable from chat. So if your chat messages, anywhere you can send a hyperlink file, you're going to be able to collect that information if it's relevant and discoverable under the rules. The Carvana case, there are two decisions here touched generally on the need for contemporaneous versions, meaning a specific point in time. And what the judge essentially said here is he came up with a strategy to test a tool and see what people could really get, and a process. He came up with a workflow. So the Carvana case is really the next step in the hyperlinked files analysis, where you want to come up with a workflow. You're no longer arguing, I don't have to produce this information. Now you're trying to figure out how to make it happen and what the best use of tools are. The FEC tool is discussed in these cases. There's another podcast episode that I did with Armand Gungor, who built the FEC tool. If you're interested in that, just follow up with me. We just have about 30 seconds left, so I'm going to we're going to skip all of Rule 707. You can read that. Do some closing takeaways. Judge, your thoughts, and I'm just going to show the resources that are available for folks.
You know, so a lot of judges and the special masters, they're wanting more information because you guys aren't giving us enough information that we can make intelligent decisions from. You need to be prepared for the hearings. And there's been, in these cases, a lack of preparation.
Maria, your thoughts?
It's just that in the 26F conference, I think you need to expand your horizon a little bit and to start thinking about possibly Gen AI, whether or not the employers like it or not, or on the other side. But I think it is going to be coming, and keep up with the case law.
Yep. All of the cases that we discussed here today are in your resources section for the session notes, as well as a copy of the case law report that we put out at Minerva 26, discussing all of the decisions, or, you know, in broad spectrum from last year. There were more than 5,000. So thank you so much. We look forward to continuing the dialogue, and thanks, Bill, for having us.